Dear students, viewers, and the subscribers, welcome to the IAS Mentor. This would be our lecture number 69 in the series Indian Polity, where you are going to cover two important topics today. One is the Attorney General of India and the Advocate General of the states. And with the Attorney General and the Advocate General of the states, we would also be completing the topic of what is called as the executives. When I talk of executives, it includes both the union executive as well as the state executive. I think for the last 20 lectures or so, we are looking into the topic of executives. We have covered the president, we have covered the vice president, we have covered the prime minister and the council of ministers at the union level. We have covered the topic of governor, we have covered chief ministers and the council of ministers. And once we cover the attorney general and the advocate general, the topic of the executives will be done. In the next lecture, I'll do a practice question. As I already said, what helped me in clearing the examination is regular, consistent reading, but also the regular practice. So I want to incorporate that as a part of this particular series also. So as and when a substantial topics are covered, we'll do a set of practice question so that your conceptual clarity get reinforced. That's the idea of doing the practice question. All right. So with that, let us get into the topic, what is called as the Attorney General of India. So as we'll move forward, what we'll try to understand is what is the constitutional position of the Attorney General, and we'll also try to understand as to what are the powers that the Attorney General exercise under the Constitution, and also what are the immunities that is granted to the Attorney General under the Constitution. A similar provision we'll also try to understand in case of what is called as the Advocate General of the state. So this is basically what you are planning to understand. All right. But the most important thing before we get into this, who is this Attorney General? Who is the Attorney General of India? Who is the Advocate General of the states? What is the relevance of such an authority to be mentioned in the Constitution of India itself? So why it is mentioned in the Constitution of India is the Attorney General of India and of course the Advocate General of every state, they are the chief law officers of the respective government. Who is a chief law officer or who is a chief advocate of the government of India? It is the Attorney General of India. And similarly, who is the chief advocate for the each and every state government? It is the Advocate General of the concerned states. So now the students can think that why the government needs an advocate, why the government needs a lawyer. Now to the judiciary, to the courts, the state is one authority. The government is just one entity as that of an ordinary individual. So the court is not going to distinguish and differentiate be it an ordinary individual or be it a government. For them, everybody is equal. So if we have any individual cases, we can engage a counsel. So similarly, the government might also have a large number of cases. In fact, you should know that it is the government of India who is the single largest litigant in the court of law. That means either the government of India has filed case against others or it is others who have filed case against the government of India. So therefore, one single party which has got the highest number of cases in the Indian judiciary is the government of India. So therefore, the government also needs a lot of lawyers to address them. So address those cases. So in this way, the government also has a large number of advocates, but who is the chief of all these advocates is the Attorney General of India. So there's no mention of other lawyers of the government in the Constitution, but yes, the Constitution does mention about the Attorney General of India. So therefore, the Attorney General of India has very important functions to perform under the Constitution. So therefore, his office is specifically mentioned. The post of Attorney General is mentioned under Article 76 of the Constitution. And further, if you look into the Constitution, who appoints Attorney General of India? The Attorney General of India is appointed by the President of India as per Article 76. The only qualification that is given in the Constitution as to who shall be appointed as the Attorney General of India, the Constitution says that anybody who will be appointed as the Attorney General of India shall be qualified to be appointed as a judge of a Supreme Court. That means anyone who is eligible to be appointed as a judge of a Supreme Court can also be appointed as the Attorney General of India. This is the only qualification that is given in the Constitution. Apart from that, the Constitution authorizes the President to determine his service conditions. The Constitution allows or authorizes the President to determine their remuneration. So you'll have to keep this in your mind. The remuneration of the Attorney General is not mentioned in the Constitution. Their service conditions are not mentioned in the Constitution. So who is supposed to determine all those things? All these things are to be determined based on the President of India. The President will issue an order at the time of appointment of the Attorney General. So therefore, the Attorney General does not have any fixed term under the Constitution. But however, the President over a period of time, whenever they appointed the Attorney General, they are given a term of 3 years for the Attorney General of India. But what you'll have to keep in your mind is that this term is not mentioned in the Constitution. His salaries, allowances, service conditions is not mentioned in the Constitution. All these things are to be determined by the President of India. As I already said, who is his Attorney General? The Attorney General is the Chief Advocate of the Government of India. Therefore, you can infer, it is very implied that what is the primary function of the Attorney General of India is to defend the Government of India in a court of law. So, he is the Chief Advocate. So, therefore, he is to defend the Government of India whenever there is a case against the Government of India, especially in the Supreme Court of India. So, not necessarily he defends the Government of India only in the Supreme Court. He can defend the Government of India in cases in the High Courts also. So, wherever it's a very important case where there's a case against the Government of India or against the Union of India, who shall defend the Union of India is the Attorney General. But of course, there can be lot of cases against the government. So, not in all the cases the Attorney General will appear. Whatever is seen as very important for the government, so in those cases he will appear. Say for example, of late recently the Attorney General has appeared in Article 370, the case related to abrogation of Article 370, the cases related to Rafale deal, the cases related to electoral bonds. So these are all some of the important issues where the Attorney General himself has represented the Government of India. So what is his primary function? Yes, he has to defend the Government of India in a court of law. So, as already said, the Attorney General is the Chief Advocate of the Government of India. So, Attorney General, so he will not be able to address all the cases. So, below the Attorney General, there can be what is called as Solicitor Generals. Solicitor Generals. So, you can consider them to be a deputy to the Attorney General, and below the Solicitor General, you can have a number of what is called as Additional Solicitor Generals, ASG. And below that you can have number of other advocates who appear for the Government of India. But however, who is on top of all these people? It is the Attorney General. So the primary function is to defend the Government of India in a court of law. If he is not able to appear, then he may send the Solicitor General or the Additional Solicitor Generals also. It depends upon the gravity of the case. So his primary function is to defend the Union government in a court of law. Apart from that, the Attorney General also give a legal opinion on various matters. So whenever the government asks for various legal opinion on a number of issues, sometimes even before going to the court, the Government of India may ask a legal opinion to the Attorney General. So in those cases, the legal opinion may be given by the Attorney General, that is a legal advice may be given. So he may defend the Government of India in a court of law. He may give what is called as the legal advice or the opinion. And apart from that, any other function which is of legal character as directed by the President of India shall also be performed by the President. So three important areas where he performs a function is one then is to defend the Government of India in a court of law, to perform such other duties as a President may ask for, and to give legal opinions. So as we'll proceed further, we'll try to understand a similar function is also performed by the Advocate General in the states. Anyways, I'll go to the Advocate General and then I'll discuss all those things. But remember, for the Attorney General to perform all those things or all these duties effectively, he needs to exercise certain rights and immunities. So therefore, under the Constitution, certain rights and immunities are also granted to the Attorney General with an objective that once these immunities are given to the Attorney General, he will be able to perform and discharge his duties very effectively. Say for example, one of his important duties is to defend the Government of India in a court of law. So therefore, the Constituent Assembly thought the Attorney General need to be given certain immunities. Say for example, there are certain privileges which is conferred upon them. So you can understand in that way. So therefore, with these privileges, he'll be able to perform his duties towards the Government of India in an effective manner. So what are such immunities and privileges which are given to the Attorney General? So I would say, rather than that, you can say certain rights and privileges, and he has got certain immunities as well. So what are those things which is given to the Attorney General? One is the Attorney General has got the right to audience in any court within the territory of India. That means the Attorney General of India has a right to move in any court within the territory of India. He can be an audience, sit and listen to the hearings in any court in India without the permission of the court. So no court can stop him from being an audience in any court. But however, that is not the case with regard to the other ordinary individuals. If we have to be an audience in any court, we need to take the permission of the court. But that is not required for whom? That is not required for what is called as the Attorney General of India. And apart from that, the Attorney General also has the right to speak and take part in the proceedings in both the houses of the Parliament or any of the parliamentary committees whenever he is called upon to do so. So the Attorney General can be summoned by the government, and therefore the government, on behalf of the government, he can take part in the proceedings in the Parliament. Now, although remember, the Attorney General is not a member of Parliament, but he can take part in the proceedings in the Parliament. He can debate in the Parliament. Without, the only restriction for the Attorney General is the Attorney General will not have the right to vote. But try to keep this in your mind whenever the Attorney General is taking part in the proceedings in the Parliament, when he is debating in the Parliament like the other members of Parliament on a specific issue or in the parliamentary committees, he will have the same immunities and privileges as that of the members of the Parliament. In fact, later I will discuss this, so we have not yet gone to that particular area. There are certain immunities and privileges which are given to the members of the Parliament under Article 105. And similar immunities and privileges are also given to the members of the state legislature under Article 194. So we'll understand as we'll proceed with the other topics in the later stages. Now these immunities and privileges are given to the members of the Parliament and the state legislature with certain objective. And what is the objective with which these immunities and privileges are given to them? The objective with which these immunities and privileges are given to them, that these immunities will help the members of the Parliament to perform their duties effectively. So therefore, when the Attorney General is taking part in the proceedings in the Parliament or in the state legislature, the Attorney General shall also exercise certain privileges. The only thing which he cannot exercise as that of the members of the Parliament is that he will not have the right to vote in the Parliament. Apart from right to vote in the Parliament, he will have the right to freedom of speech and other privileges as that of the members of the Parliament in case if he is taking part in the proceedings in the Parliament. But without the right to vote, because Attorney General is not a member of Parliament. So these are all some of the privileges and immunities that is given to the Attorney General. But however, at the same time, there are certain limitations upon the Attorney General. The Attorney General should not do all these things. The first and foremost is the Attorney General should not hold a brief against the government. So what does it mean? The Attorney General should not hold a brief against the government. When I say that the Attorney General should not hold a brief against the government, the Attorney General should not appear against the government of India in a court of law. In fact, he should not do anything that would go against the interest of government of India in a court of law, because the Attorney General is the chief advocate of the government. So he cannot appear against the government. Why? Because although the Attorney General is there, who is the chief advocate of the government of India, nothing in law prevents the Attorney General to have what is called as a private client. So the Attorney General can also have what is called as a private client. So while if there are two private clients, the Attorney General, if the case is between two private clients, the Attorney General can appear on behalf of any of the private client as long as it is not affecting the interest of the state, if it is not affecting the interest of the government. But however, if he is appearing on behalf of one party which may affect the interest of the government, then he should not do that. So that is what the Constitution says, that he should not hold a brief against the government. That means you should also have an understanding. Nothing in the Constitution or in the law prevents the Attorney General from having what is called as a private client. But the only thing that he has to make sure that is that he should not appear against any of the, he should not have a client for whom he will appear in a court of law which will go against the interest of the government. That he should not do. So the Supreme Court of India has very clearly said that the Attorney General is not an office, or it is not an employment under the government of India. Rather, the relationship between the government of India and the Attorney General is that of what is called as a client and a counsel. So the government of India is a client and the Attorney General is a counsel. So therefore, the Attorney General can have a number of clients. So this is exactly what has been held by the Supreme Court in this particular regard. So this is something that you'll have to clearly keep it in your mind. So I am sure that till this point of time it is very clear. So he should not hold a brief against the government. and he should not defend the people in a criminal case without the permission of the government. So he can defend the people in a criminal case, but not without the permission of the government. He should not hold a brief against the government. He should not accept the appointment as a director of any company without the permission of the government. So these are all some restrictions that is there in the constitution. But however, despite that, it has been clarified that Attorney General can have a private client but without affecting the interest of the state. So this is basically what you'll have to understand with regard to the Attorney General of India. Now, similar to that of the Attorney General of India, in every state there is someone who is called as the Advocate General. The Advocate General is the chief advocate of the concerned state government. So every state will have their own Advocate General. So who is going to appoint the Advocate General of the state? The Advocate General of the state is appointed by the governor of that concerned state. Now, one thing that you have to keep in your mind as a general principle is that both the Attorney General and the Advocate General, they are all appointed by the respective executive head of the state. That is, in case of the union, the Attorney General, he is appointed by the president. In case of the Advocate General, he or she is appointed by the governor of the concerned state. But in both the cases, it is based on the aid and advice of the respective Council of Ministers. So this is neither a discretionary power of the president with regard to appointment of Attorney General or a discretionary power of the governor with regard to appointment of the Advocate General of the states. So the only thing that is given in the constitution is that who can be appointed as the Advocate General is someone who should have the eligibility to be appointed as a judge of a high court. So try to remember this. In case of Attorney General, he should have the qualification to be appointed as a judge of a Supreme Court. In case of Advocate General of a state, he or she should have the qualification to be appointed as a judge of a high court. So this is the basic understanding you should have. And apart from that, the constitution does not provide for any fixed term or remuneration to the Advocate General of the states as well. As per Article 165 of the Constitution, whatever is their term shall be fixed by the governor. Whatever is their service conditions and remunerations, they all to be fixed by the governor of that concerned state. So as per what the governors has been doing is normally the term of the Advocate General is usually for a period of 3 years. And it is not necessary they will complete the 3-year term, but the government, if they want, they can give the extension also. So normally it is a practice that whenever the government changes, whether the Advocate General term is over or not, usually the Advocate General submits the resignation, because when the new government comes, they may ask the Advocate General to resign. So therefore, the Advocate General on his own will resign whenever the government changes. So similarly, the Attorney General will also resign whenever the government changes. So therefore, there is no security of tenure for the Attorney General or the Advocate General under the Constitution of India. So similar to that of the Attorney General, the Advocate General also performs certain functions, and the most important function of the Advocate General is to defend the state government in a court of law. He can defend the state government in the Supreme Court, High Courts, in any of the other courts, depending upon where the state government want the Advocate General to defend it in a court of law. So therefore, try to understand that similar to that of the Attorney General, the Advocate General is the chief advocate of the state government, defending the interests of the state government in various courts. But all the cases of the state government cannot be defended only by the Advocate General. So therefore, there are a lot of other officers also, law officers for the state government. But who is the chief of all those things? It's the Advocate General. So below the Advocate General, there are a number of additional Advocate Generals and other public prosecutors or other advocates who defend the government in a court of law. But who is the chief is the Advocate General of the state. So what are the functions to be performed by the Advocate General of the state? So the first and foremost function is to defend the state government in a court of law. So whenever the state government asks for it, the Advocate General has to defend. Apart from that, he is also supposed to give legal opinion and advice to the state government whenever the opinion is sought from the Advocate General. Apart from that, he is also supposed to perform any other duties which is legal in character as and when directed by the governor of the concerned state. The only difference is here you will have to replace the word Attorney General by Advocate General, and you will have to replace the central government by state government, and you will have to replace in case in this particular case, as I already said, the Attorney General by the Advocate General. So that's the only thing that you will have to probably keep in your mind. Now, similar to that of the Attorney General, the Advocate General also has certain rights and immunities. So what are the rights and immunities? The Attorney General will have the same immunities as that of the members of the Parliament when he is taking part in the proceedings in the Parliament and the parliamentary committees. Similarly, the Advocate General will have the same immunities and privileges when he is taking part in the various committees or in the proceedings in the state legislature as the privileges and immunities that would be exercised by the members of the state legislature. The only difference is that the Attorney General, or for that matter the Advocate General, they will not have the right to vote in the parliamentary proceedings or in the proceedings in the state legislature. Without the right to vote, they will have the right to freedom of speech and all those things, but not the right to vote. So the same restrictions will apply here as well. And the Attorney General, we have seen that he can be an audience in any court within the territory of India, whereas the Advocate General will have the right to audience in any court within the territory of the concerned state. So within the state, he can be an audience in any court. He doesn't have to take the permission of the courts. But whereas as an ordinary individual, as I already said, we do not have that permission. The only thing that you have to keep in your mind is the Attorney General in any court within the territory of India, the Advocate General within the territory of the concerned state. So therefore, the position of Attorney General is, or the Advocate General is similar to that of the Attorney General, but at the state level. And similarly, there are certain limitations to the Advocate General of the state, that he should not hold a brief against the state government, that he should not do anything legally that would hurt the interest of the concerned state government. If you want to appear for the private clients in the criminal cases, he can do so with the permission of the state government. If he was to be appointed as a director of any of the company, that can be done only after taking the permission of the state government. And in fact, the Advocate General is also free to have what is called as private clients, because the Advocate General of the state is also not a full-time employee of the state government. Rather, the relationship between the Advocate General and that of the state is that of what is called as client and a counsel. So this is basic understanding you should have. So I am quite clear now you will have a proper understanding of all these things, that as to what is the constitutional position of the Attorney General, and therefore what is the constitutional position of the Advocate General of the states. In both the cases, try to understand, be it the Attorney General or be it the Advocate General, they have no fixed term, they have no service conditions laid down in the constitution. In both the cases, they resign normally whenever the government changes. But the constitution does not tell them to resign, but normally they resign whenever the government changes. They have the same rights and privileges as that of the members of the parliament and the state legislature, except what is called as the right to vote. And they almost exercise what is called as similar type of limitations. In both the cases, it is not considered to be an employment under what is called as the respective government. So these are all the basic understanding you should have with regard to the office of the Attorney General as well as the Advocate General. Now with that, we'll move to the practice question. So let us try to complete the practice question. So consider the following statements with regard to the Attorney General of India. Statement 1. The Attorney General is appointed for a period of 3 years. It is not mentioned in the constitution, but here the question is, consider the following statements with regard to the Attorney General of India. It is not asking whether it is mentioned in the constitution or not. What is the practice? The Attorney General is appointed for a term of 3 years. He is also the Law Minister of India. So in fact, the Attorney General is not part of the Council of Ministers. So try to keep this in your mind. He has a right to take part in the debates in the Parliament and vote in the houses of the Parliament. Is it allowed for him to do that? How many of the statements given above are correct? If you have listened to my lecture, it is very easy for you to answer this particular question. So you can put your answers in the comment box. Please do participate in the questions and the other questions that I asked during the discussion. That is going to really motivate me in doing the other lectures as well. All right. So with that, I am coming to the end of this particular lecture. So I am very sure that this lecture is going to be extremely useful. So do watch all the lectures in a series and then do take up the practice question. So in the next lecture, I'll come up and do a practice question. I'm just repeating it again, that these are the practice questions which helped me to clear this examination. So I wish every student does that so that they can also clear this examination. All right. So with that, I'll wind up the lecture. But before I wind up the lecture, if you like this lecture, please do share it with your friends and other family members who are preparing for the examination. It is extremely going to be useful for the students preparing for the UPSC examination and also other competitive examination. If you have any queries, please do reach out to me. Think me as a mentor, a friend or a brother, whatever you wish, but do reach out to me, and if you have any doubts, you can get it clarified. Thank you very much. All the very best.